Question 1. Topic: Property division in divorce. In a high-stakes environment where multiple challenges arise during the division of assets in a divorce, a couple is disputing the classification of a property acquired during the marriage. The wife argues that the vacation home purchased in her name using funds from an inheritance should be considered separate property, while the husband contends that it is marital property since they both contributed to maintenance and improvements of the home. How would the court likely rule on this issue? A. The vacation home is separate property because it was purchased with inherited funds. B. The vacation home is marital property because both spouses contributed to its upkeep. C. The vacation home is separate property unless the inherited funds were commingled with marital assets. D. The vacation home is marital property only if the title is in both spouses' names. Answer: C. That vacation home is separate property unless the inherited funds were commingled with marital assets. Explanation: under equitable distribution principles followed in most U.S. states, inherited assets are typically classified as separate property, meaning they are not subject to division in a divorce. However, if inherited funds are commingled with marital assets, such as depositing them into joint account or using them in a way that benefits both spouses, the inherited property can lose its separate classification. In this scenario, the wife initially had strong claim that the home was separate property. However, the court would where the marital efforts significantly increased the home's value, such as renovations, mortgage payments, or maintenance funded by marital income. If such contributions were significant, the court might determine that the home has marital interest, meaning the husband could claim portion of its value. Why not they? While inheritance funds typically create separate property, the act of using them to acquire property used by both spouses complicates this classification. Why not B? The mere fact that both spouses contributed to maintenance does not automatically convert an asset to marital property unless the contributions significantly increased its value. Why not D? Property does not become marital simply because both names are on the title. The source of funds and level of contribution matter more. Relevant law: equitable distribution versus community property principles, marital versus separate property classification. Question 2. Topic: child custody and parenting plans. While investigating a complicated issue between different custody arrangements, a court must decide whether to grant joint legal custody or sole custody to one parent. The father has a history of domestic violence allegations, although no convictions, while the mother has demonstrated strong parental involvement and stability. The father insists that denying him joint custody violates parental rights. What is the most likely outcome in this case? A. The court would award joint custody as both parents have equal legal rights to their child. B. The court will likely grant sole custody to the mother due to concerns about the child's best interests. C. The court would award sole custody to the mother but ensure the father gets extensive visitation rights. D. The court must give joint custody unless there is conviction for domestic violence. Answer: B. The court will likely grant sole custody to the mother due to concerns about the child's best interests. Explanation: custody decisions are based on the best interest of the child, a standard which considers various factors such as stability, parental fitness, history of abuse, and the ability to co-parent effectively. Although the father has no convictions for domestic violence, allegations alone may still weigh heavily in the court's analysis. Most prioritize the child's safety and well-being over parental rights. History of domestic violence, even without conviction, may lead judge to determine that sole custody is in the child's best interest. In this case, since the mother has shown stability and active parental involvement, she is the likely choice for sole custody. Why not they? While both parents have equal legal rights, custody is based on what is best for the child, not just parental equality. Why not C? Courts may grant some level of visitation, but if safety concerns exist, visitation could be limited or supervised. Why not D? Courts do not require criminal conviction to consider allegations of domestic violence when determining custody arrangements. Relevant law: best interest of the child, standard legal custody versus physical custody, domestic violence, and custody considerations. Question 3. Topic: spousal support alimony during a major transformation where existing methods of financial dependency are reassessed. In a divorce case, a spouse who was financially dependent throughout a 25-year marriage is seeking permanent alimony. The other spouse argues that rehabilitative alimony should be sufficient since the dependent spouse has a college degree and prior work experience. What factors will most influence the court's decision? A. The length of the marriage and the dependent spouse's inability to maintain the same standard of living. B. The fact that the dependent spouse has college degree and can find employment. C. The paying spouse's ability to afford alimony payments. D. The existence of prenuptial agreements, which automatically waive alimony rights. Answer A. The length of the marriage and the dependent spouse's inability to maintain the same standard of living. Explanation. Courts consider multiple factors when awarding spousal support, but two of the most critical are the length of the marriage. Long-term marriages, 20 years, often justify permanent alimony, particularly if one spouse was financially dependent for the duration. The recipient's ability to maintain the marital standard of living. If spouse gave career opportunities to support the marriage. G. Raising children, managing the household. The court may grant long-term or permanent alimony rather than temporary or rehabilitative alimony. Why not B? While education and work experience are factors, they do not automatically eliminate the need for long-term support, especially if the spouse has been out of the workforce for decades. Why not C? The ability to pay is relevant, but it does not outweigh the dependent spouse's needs and the fairness of support after long marriage. Why not D? Prenuptial agreements can waive alimony rights, but they are not always automatically enforceable. Courts may set them aside if they are deemed unconscionable or if circumstances have significantly changed. Relevant law. Types of alimony: permanent, rehabilitative, temporary. Factors affecting spousal support: modification and termination of alimony. Question 4. Topic: Spousal support alimony during a comprehensive review of a process that needs improvement. A state legislature is considering a revision to its alimony laws to address concerns about fairness and long-term financial stability for divorced spouses. One proposed change is to limit permanent alimony to cases where the recipient spouse can prove a significant economic disadvantage due to the marriage. The legislature is debating whether cohabitation with a new partner should automatically terminate alimony obligations. Given these considerations, how would courts likely assess alimony awards under the revised framework? A. Alimony would be granted only if the recipient spouse can prove they made financial sacrifices during the marriage that impacted their earning capacity. B. Courts would no longer consider the length of the marriage and would instead focus solely on the recipient spouse's current financial needs. C. If the recipient spouse moves in with new partner, alimony would automatically terminate regardless of the financial interdependence of the new relationship. D. The paying financial ability to continue support would no longer be a factor in determining alimony awards. Answer: alimony would be granted only if the recipient spouse can prove they made financial sacrifices during the marriage that impacted their earning capacity. Explanation: under traditional alimony principles, courts consider multiple factors when determining whether spousal support is appropriate, including the length of the marriage, financial contributions of both spouses, and the recipient spouse's ability to become self-sufficient. The proposed legislative change aligns with the modern trend of limiting permanent alimony unless there is clear evidence that the recipient spouse suffered economic harm due to the marriage. G. Sacrificing career advancement to raise children. A. Correct. This reflects fairness-based approach where the court must consider the financial impact of the marriage on the low-earning spouse. Case law often supports this reasoning, emphasizing the role of marital sacrifices in determining alimony. B. Incorrect. The length of the marriage is a crucial factor in determining spousal support. Long-term marriages often lead to more extended support periods. C. Incorrect. While some jurisdictions allow alimony upon cohabitation, courts typically examine whether the new relationship creates financial interdependence. Automatic termination without such analysis is uncommon. D. Incorrect. The paying spouse's ability to afford alimony is always a factor in determining fair award, and it cannot be ignored. Question 5. Topic: Child custody and parenting plans in a high-stakes environment where multiple challenges affect parental relationships. A court is tasked with deciding custody arrangements for a child whose parents have conflicting claims. The mother argues that she should receive sole custody because the father travels frequently for work, making joint custody impractical. The father, on the other hand, asserts that despite his travel schedule, maintains a close and meaningful relationship with the child and has adequate child care arrangements during his absence. How should the court balance these competing claims in accordance with the best interest of the child standard? A. The court should automatically award sole custody to the parent who is physically present most of the time. B. The court should evaluate the stability of each parent's household, the child's emotional bond with both parents, and any history of caregiving before making a decision. C. The father's travel schedule should disqualify him from joint custody, as frequent travel inherently disrupts stability. D. The court should divide custody strictly on the amount of time each parent can be physically present without considering other factors. Answer: B. The court should evaluate the stability of each parent's household, the child's emotional bond with both parents, and any history of caregiving before making a decision. Explanation: Custody determinations are guided by the best interest of the child standard, which considers various factors such as parental involvement, stability, the emotional well-being of the child, and the ability to provide a nurturing environment. A. Incorrect. Physical presence is an important factor, but not the sole determinant. The court must consider the overall relationship between the child and each parent. B. Correct. Courts examine a range of factors, including the child's attachment to both parents, the ability to provide stable home, and any history of caregiving. This approach aligns with legal precedents that prioritize holistic assessment. C. Incorrect. Parents' travel schedule insufficient to disqualify them from joint custody. Courts may consider alternative caregiving arrangements to ensure continuity in the child's life. D. Incorrect. Custody decisions are not based solely on the percentage of time each parent is physically present, but on broader considerations of the child's well-being. Question 6. Topic: Property division in divorce. While analyzing the root causes of sequential problems in asset division, a court must decide how to distribute a family business jointly owned by a divorcing couple. The husband initially founded the business before marriage, but significantly expanded it with the wife's active involvement and financial contributions. The business has grown substantially in value, and both parties claim a rightful share. The court determined the appropriate division of this asset. A. The business remains solely the husband's separate property because he founded it before the marriage, regardless of any later contributions. B. The business should be split equally, as all assets acquired during the marriage are automatically considered marital property. C. The court should distinguish between the portion of the business that was separate property and any increase in value attributable to the wife's contributions, dividing only the latter. D. The only entitled to financial compensation for the exact amount of money she invested in the business, with no claim to any appreciation. Answer: C. The court should distinguish between the portion of the business that was separate property and any increase in value attributable to the wife's contributions, dividing only the latter. Explanation: Property division in divorce follows either equitable distribution or community property principles, depending on the jurisdiction. Most states follow equitable distribution, which considers the financial and non-financial contributions of both dividing assets. A. Incorrect. While the business may have originated as separate property, any appreciation in value due to marital efforts or joint investments is typically subject to division. B. Incorrect. Not all marital assets are automatically split 50-50. Courts consider various factors, including contributions and financial needs. C. Correct. Courts often distinguish between the original value of separate property asset and any appreciation. Marital contributions. The wife's involvement justifies her claim to share of the increase in value. D. Incorrect. The wife's financial and managerial contributions likely played role in the business's success, making her entitled to portion of the appreciation, not just reimbursement of initial investments. Question 7. Topic: Prenuptial agreements. During a comprehensive review of a process that needs improvement, a wealthy individual is drafting a prenuptial agreement to protect significant premarital assets. The agreement stipulates that in the event of divorce, the future spouse will waive all rights to spousal support and any increase in value of the individual's business. However, the future spouse claims that they were pressured into signing the agreement with legal counsel and did not fully understand its implications. Given these facts, what factors would a court likely consider in determining whether the prenuptial agreement is enforceable? A. Whether both parties had independent legal counsel, whether the agreement was signed voluntarily, and whether the terms are unconscionable. B. Whether the wealthier spouse had more financial resources at the time of signing, regardless of other circumstances. C. Whether prenuptial agreements are always upheld as long as they are written and signed before marriage. D. Whether the less wealthy spouse can prove they would suffer economic hardship due to the agreement, regardless of whether they signed it voluntarily. Answer: A. Whether both parties had independent legal counsel, whether the agreement was signed voluntarily, and whether the terms are unconscionable. Explanation: Courts analyze prenuptial agreements based on voluntariness, fairness, and full disclosure of if a spouse was pressured into signing, lacked legal representation, or was unaware of critical financial details. The court may invalidate the agreement. A. Correct. Courts examine legal representation, voluntariness, and fairness to determine validity. B. Incorrect. Financial disparity alone does not invalidate an agreement unless other factors like coercion exist. C. Incorrect. Prenuptial agreements are subject to judicial scrutiny and are not automatically enforceable. D. Incorrect. Hardship is considered, but voluntariness and fairness are primary concerns. Question 8. Topic: Child support modifications in a high-stakes environment where multiple challenges affect parental relationships. A non-custodial parent loses their job and requests a modification to reduce child support payments. The custodial parent argues that the non-custodial parent has significant savings and could still afford the payments. What is the most likely outcome based on typical child support laws? A. The court will deny the request unless the non-custodial parent has been unemployed for more than 6 months. B. The court will review the parent's current financial circumstances, including income, assets, and efforts to secure new employment before making a decision. C. The court will automatically grant the reduction as long as the parent is unemployed. D. The court will increase child support obligations for the custodial parent to compensate for reduction in payments. Answer: B. The court will review the parent's current financial circumstances, including income, assets, and efforts to secure new employment before making a decision. Explanation: Child support modifications are based on substantial changes in financial circumstances. Courts evaluate income, assets, and job-seeking efforts before modifying obligations. A. Incorrect. There is no strict 6-month rule. The decisions are case-specific. B. Correct. Courts assess finances holistically before modifying payments. C. Incorrect. Unemployment alone does not guarantee a reduction, especially if the parent has significant assets. D. Incorrect. Custodial parents are not automatically required to increase their financial contributions. Question 9. Topic: Adoption and parental rights termination. While analyzing the root causes of sequential problems in family law, a state court is handling an adoption case where a biological father is contesting the termination of his parental rights. The father was not married to the mother and had minimal contact with the child, but he now seeks custody. The mother's new spouse has filed to adopt the child. How should the court approach the case? A. The court will automatically grant the adoption because the father was not married to the mother. B. The court will examine the father's past efforts to establish relationship and his ability to provide stable home before terminating his rights. C. The father's lack of contact means he has no legal standing to contest the adoption. D. The adoption will be denied because biological parents always have superior rights over step-parents. Answer: B. The court will examine the father's past efforts to establish relationship and his ability to provide stable home before terminating his rights. Explanation: Courts prioritize the child's best interests, considering parental involvement, financial stability, and past behavior before terminating rights. A. Incorrect. Marital status alone does not determine parental rights. B. Correct. The court evaluates the biological parent's role before terminating rights. C. Incorrect. The father may have legal standing depending on state laws. D. Incorrect. Step-parents can obtain custody if it benefits the child. Question 10. Topic: Domestic violence and protective orders. During a comprehensive review of a process that needs improvement, a court is considering reforms to its domestic violence protective order procedures. A petitioner seeks an order against their former spouse, claiming repeated harassment and threats. However, the accused denies wrongdoing and argues there is no physical evidence of abuse. What factors will the court likely consider in deciding grant the order? A. Only physical violence can justify issuing a protective order. B. The court will assess the credibility of testimony, prior incidents of abuse, and any threats made, even if physical violence is absent. C. The protective order will be automatically denied if the accused disputes the claims. D. Protective orders can only be issued if the petitioner has suffered a physical injury. Answer: B. The court will assess the credibility of testimony, prior incidents of abuse, and any threats made, even if physical violence is absent. Explanation: Courts consider all forms of abuse, including emotional, verbal, and psychological harm. A. Incorrect. Threats and harassment can justify an order. B. Correct. Courts review evidence holistically, not just physical harm. C. Incorrect. The burden of proof does not require absolute certainty. D. Incorrect. Physical injury is not a prerequisite for protection. Question 11. Topic: Spousal support and alimony during a comprehensive review of a process that needs improvement. A divorcing couple is disputing the duration of spousal support. The high-earning spouse argues that the recipient spouse should become self-sufficient within 2 years, while the recipient claims they need indefinite support due to their inability to find comparable employment. Which factor is most relevant in determining the length of support? A. The length of the marriage, the recipient's ability to become self-sufficient, and the standard of living established during the marriage. B. Only the income difference between the two spouses. C. The paying spouse's preference on how long they are willing to provide support. D. Whether the recipient spouse has remarried, regardless of their financial needs. Answer A. The length of the marriage, the recipient's ability to become self-sufficient, and the standard of living established during the marriage. Explanation. Courts assess marriage duration, financial need, employment potential, and lifestyle to set support duration. A. Correct. Long marriages and financial dependence can justify longer support. B. Incorrect. Income difference is factor, but not the sole determinant. C. Incorrect. Support obligations are legally determined, not based on personal preference. D. Incorrect. Remarriage affects support, but financial need is also crucial. Question 12. Topic: Child custody and relocation. While analyzing the root causes of sequential problems in family law, a custodial parent receives a job offer in another state and wants to relocate with their child. The non-custodial parent opposes the move, arguing that it will interfere with their visitation rights. What will the court most likely consider when making a decision? A. The best interests of the child, including educational opportunities, family support, and impact on relationships with both parents. B. Only whether the custodial parent has the right to move. C. The preferences of the custodial parent without regard to the child's welfare. D. Whether the non-custodial parent can prove the move is financially motivated. Answer A. The best interests of the child, including educational opportunities, family support, and impact on relationships with both parents. Explanation. Relocation cases focus on the child's best interests, parental involvement, and stability. A. Correct. Courts weigh multiple factors, not just parental rights. B. Incorrect. Relocation rights depend on custody agreements and child welfare. C. Incorrect. Courts prioritize the child's needs over parental convenience. D. Incorrect. Financial motives alone do not determine relocation approval. Question 13. Topic: Division of marital assets. As part of an ongoing investigation into a complex legal matter, a couple in a community property state is divorcing and disputing ownership of a business started by one spouse before marriage. The other spouse contributed to the business's growth during the marriage. How will the court likely divide the business? A. The increase in value during the marriage may be considered marital property, even if the business was initially separate property. B. The spouse who started the business keeps 100% ownership since it was started before marriage. C. The business is automatically divided equally between both spouses, regardless of contributions. D. The business remains entirely separate property, with no consideration for marital efforts. Answer A. The increase in value during the marriage may be considered marital property, even if the business was initially separate property. Explanation. Courts distinguish separate versus marital property and may divide increased value from marital efforts. A. Correct. Growth during marriage may be subject to division. B. Incorrect. Courts often consider contributions from both spouses. C. Incorrect. Automatic 50-50. Division applies only in some states. D. Incorrect. Marital contributions impact property division rulings. Question 14. Topic: Parental rights and adoption. In a high-stakes environment where multiple challenges affect parental relationships, a stepfather wants to adopt his wife's child. The biological father objects but has not paid child support or visited in 5 years. Under what circumstances might the court terminate the biological father's parental rights? A. If the father has abandoned the child by failing to maintain contact and support. B. Only if the father signs voluntary termination of parental rights. C. Parental rights can never be terminated unless the parent commits crime. D. The court will not consider adoption unless both biological parents agree. Answer A. If the father has abandoned the child by failing to maintain contact and support. Explanation. Courts may terminate parental rights for abandonment, neglect, or unfitness. A. Correct. Lack of support contact may be grounds for termination. B. Incorrect. Courts can terminate rights involuntarily if justified. C. Incorrect. Criminal activity is not the only reason for termination. D. Incorrect. Adoption can proceed if termination is warranted. Question 15. Topic: marital debt responsibility during a comprehensive review of a process that needs improvement. A divorce in couple disputes responsibility for credit card debt incurred during the marriage. One spouse claims the debt was from personal luxury spending, while the other argues it was for household expenses. How will the court likely rule? A. Debt incurred during the marriage is generally shared unless proven to be solely for personal use without mutual benefit. B. The spouse who earn less money is automatically responsible for the debt. C. Debt is always split 50-50 regardless of its purpose. D. The court does not consider how the debt was used. Answer A. Debt incurred during the marriage is generally shared unless proven to be solely for personal use without mutual benefit. Explanation: marital debt is typically divided based on its purpose and benefit to the marriage. A. Correct. Courts assess whether both spouses benefited. B. Incorrect. Income levels do not automatically determine responsibility. C. Incorrect. Some debts may be assigned to one spouse. D. Incorrect. Courts review how debt was used. Question 16. Topic: grandparents' visitation rights. As part of an ongoing investigation into complex legal matter, grandparents seek visitation rights after their child's divorce. The custodial parent refuses to allow visits. What must the grandparents prove to obtain court-ordered visitation? A. That visitation is in the best interest of the child and that denying it would harm the child. B. That they have legal right to visitation regardless of the parent's wishes. C. That they are financially capable of caring for the child. D. That the custodial parent must share parental authority with them. Answer A. That visitation is in the best interest of the child and that denying it would harm the child. Explanation: courts balance parental rights and child welfare in granting visitation. A. Correct. Grandparents must show child's best interests. B. Incorrect. Parents have primary authority over visitation. C. Incorrect. Financial status is not the key factor. D. Incorrect. Custodial parents are not required to share authority. Question 17. Topic: child custody and relocation disputes during a comprehensive review of a process that needs improvement. A custodial parent plans to move out of state for a new job opportunity. The non-custodial parent objects, arguing that the relocation would disrupt their visitation rights. What factors will the court most likely consider in deciding whether to approve the relocation? A. The best interests of the child, including educational opportunities and emotional stability. B. The custodial parent's financial status alone. C. The non-custodial parent's ability to relocate as well. D. The number of years the parents have been separated. Answer A. The best interests of the child, including educational opportunities and emotional stability. Explanation: courts prioritize the child's best interests when evaluating relocation requests. Factors include educational benefits and medical access in the new location. Impact on the child's relationship with the non-custodial parent. Parental motives, ensuring the move isn't intended to alienate the other parent. Feasibility of modified visitation schedules to maintain parental involvement. If the relocation benefits the child without harming their bond with both parents, courts may approve the move. Question 18. Topic: marital property and debt division. While analyzing the root causes of sequential problems in family law, a divorcing couple argues over who should be responsible for a large credit card debt. The debt was accumulated during the marriage, but only one spouse used the card. How will the court likely distribute the debt? A. The debt will be classified as marital property and divided equitably. B. The spouse who used the card will be solely responsible. C. The debt will be assigned to the high-earning spouse. D. Debt division is not addressed in divorce proceedings. Answer A. The debt will be classified as marital property and divided equitably. Explanation: courts classify debts incurred during marriage as marital liabilities, even if only one spouse used the account. Factors affecting division include whether the debt benefited both spouses, e.g. household expenses, who was responsible for accumulating the debt and their financial situation, state laws. Some states divide debt equally, community property states, while others divide based on fairness, equitable distribution states. Even if only one spouse used the credit card, both may be responsible if the debt was marital. Question 19. Topic: grandparents' rights and child visitation. As part of an ongoing investigation into complex legal matter, child's parents divorce and the custodial parent denies the grandparents' visitation. The grandparents file for court-ordered visitation. What will the court consider in making decision? A. The child's best interests, including emotional bonds with the grandparents. B. The grandparents' financial ability to care for the child. C. Whether the grandparents live in the same state. D. Grandparents automatically have visitation rights. Answer A. The child's best interests, including emotional bonds with the grandparents. Explanation: grandparents do not have automatic visitation rights in most states. However, courts consider the strength of the relationship between the child and grandparents, the impact of denying visitation on the child's emotional well-being, parental rights as courts prioritize fit parents' decision, state laws, which vary in granting grandparent visitation based unique circumstances. Question 20. Topic: Adoption and parental consent during a comprehensive review of a process that needs improvement. A stepfather seeks to adopt his wife's child from previous marriage. The biological father, who has not seen the child in years, objects to the adoption. Under what circumstances can the court terminate the biological father's rights? A. If the biological father has abandoned the child or is unfit. B. If the stepfather earns more money than the biological father. C. If the mother and stepfather request termination without evidence. D. If the child does not want to see the biological father. Answer A. If the biological father has abandoned the child or is unfit. Explanation: courts can terminate parental rights if the biological parent abandoned the child, no contact support for an extended time, the parent is unfit, substance abuse, neglect, abuse. Termination is in the child's best interest, often to allow adoption. Courts require strong evidence to sever parental rights, protecting both parents' and children's legal interests. Question 21. Topic: Alimony modification and financial changes. While analyzing the root causes of sequential problems in family law, a spouse paying alimony loses their job and requests a modification. The recipient spouse opposes the request. What will the court most likely consider? A. Whether the paying spouse's job loss is involuntary and affects their ability to pay. B. The recipient spouse's preference to continue receiving the original amount. C. Whether the paying spouse will find new job within 6 months. D. Whether the marriage lasted more than 10 years. Answer A. Whether the paying spouse's job loss is involuntary and affects their ability to pay. Explanation: courts evaluate job loss and financial hardship when modifying alimony. Key factors include whether unemployment is voluntary or involuntary, the paying spouse's efforts to find new employment, the recipient's financial dependency and need for continued support. Alimony modifications require substantial changes in circumstances. Question 22. Topic: Restraining orders and evidence requirements. As part of an ongoing investigation into a complex legal matter, a person requests a restraining order against their ex-partner, citing verbal threats. What type of evidence will the court require? A. Witness testimony, text messages, or police reports showing threats. B. Only the accuser's statement without additional proof. C. The financial status of the accused party. D. Whether the accused denies the allegations. Answer A. Witness testimony, text messages, or police reports showing threats. Explanation: courts require documented threats or credible testimony before granting restraining orders. Text messages, emails, or recorded threats strengthen claims. Police reports provide official documentation. Witness statements support credibility. False accusations do not automatically result in restraining orders without evidence. Question 23. Topic: Divorce and business asset division during a comprehensive review of a process that needs improvement. A divorcing couple owns a business together. How will the court determine how to divide the business? A. By evaluating the business's value and each spouse's contributions. B. Automatically awarding the business to the spouse who started it. C. Selling the business and splitting the profits equally. D. Giving full control to the high-earning spouse. Answer A. By evaluating the business's value and each spouse's contributions. Explanation: courts assess business valuation, assets, revenue, debts, spousal contributions including labor and investments, buyout options if one spouse wants to retain the business. The goal is equitable distribution, not necessarily 50-50 split. Question 24. While updating traditional approaches where interconnections between custody laws and parental rights create legal conflicts, a mother who has sole legal custody of her child decides to relocate to another state for a job opportunity. The father, who has joint physical custody but no legal custody, objects to the move, arguing that it would disrupt his parenting time. Under the Uniform Child Custody Jurisdiction and Enforcement Act (UCJIA), which of the following factors is most likely to influence the court's decision regarding parental relocation? A. The mother's right to relocate as the custodial parent without needing the court's permission. B. The best interests of the child, including emotional, educational, and social stability. C. The father's right to veto the move due to his joint physical custody status. D. The state's default presumption that relocation is always in the best interests of the child. Answer: B. The best interests of the child, including emotional, educational, and social stability. Explanation: under the UCJIA and state-specific custody laws, courts prioritize the best interests of the child when deciding relocation cases. This standard evaluates factors such as the impact of relocation on the child's stability, including school, community, and extended family ties. The custodial parent's reasons for relocating. Employment opportunities, remarriage, the effect on the non-custodial parent's visitation and parental involvement, the feasibility of alternative parenting arrangements, such as modified visitation schedules. Why the other answers are incorrect. A. Incorrect. Even though the mother has sole legal custody, most states require court approval for relocation if it significantly affects the other parent's visitation rights. C. Incorrect. While the father has physical custody, this alone does not give him veto over the move. Instead, he must show how the move would negatively impact the child. D. Incorrect. No state automatically presumes that relocation is in the child's best interest. Each case is reviewed individually based on the child's needs. Question 25. During a seamless transition where continuity must be maintained between child support obligations and financial hardship exceptions, a parent who lost their job petitions the court for a reduction in child support payments. However, the receiving parent argues that the existing child support order must remain in place. Which of the following is the strongest legal basis for the court to approve the modification request? A. The paying parent's voluntary decision to leave their job, which reduces their ability to pay. B. The paying parent's financial hardship due to involuntary job loss and demonstrated efforts to seek new employment. C. The receiving parent's increased personal income making child support unnecessary. D. The passage of time since the last child support modification, regardless of financial circumstances. Answer: B. The paying parent's financial hardship due to involuntary job loss and demonstrated efforts to seek new employment. Explanation: most states allow child support modifications when substantial change in circumstances occurs, such as involuntary job loss or significant reduction in income, medical emergencies or disability affecting the ability to work, major change in the child's financial needs, e.g., increased health, education costs. To approve the modification, courts typically require evidence that the paying parent is actively seeking employment and not avoiding financial responsibility. Why the other answers are incorrect. A. Incorrect. Parent cannot reduce child support obligations by voluntarily quitting or taking a low-paying job. Courts may impute income based on prior earnings. C. Incorrect. The receiving parent's income increase does not automatically have child support unless the increase substantially changes the child's financial needs. D. Incorrect. Child support modifications are based on financial changes, not the passage of time alone. Question 26. In an environment where different components must interact within marital property division cases, a couple divorcing in a community property state disputes ownership of a business started by the husband before the marriage. The wife argues that since she contributed unpaid labor to the business during the marriage, she is entitled to a share of its value. What principle is most likely to apply in this case? A. The entire business is separate property because it was started before the marriage. B. The increase in the business's value during the marriage may be considered community property if marital effort contributed to its growth. C. The wife is only entitled to share if she can prove she directly invested money into the business. D. The business must be divided equally between both spouses, regardless of contributions. Answer: B. The increase in the business's value during the marriage may be considered community property if marital effort contributed to its growth. Explanation: under community property principles, business started before marriage is separate property, but any increase in value due to marital efforts can be classified as community property. Courts often use formulas such as the Van Kamp approach when business increases in value due to market force rather than spousal contributions. The owner retains most of the value. The Pereira approach, when spouses' efforts G. Unpaid labor managerial decisions contributed to business growth. Courts allocate portion of the appreciation to the marital estate. Why the other answers are incorrect. A. Incorrect. The original business may be separate property, but growth due to marital effort can be community property. C. Incorrect. Non-monetary contribute. G. Labor management are considered in property division. D. Incorrect. Community property states do not require equal division of every asset, only fair division. Question 27. When developing a solution that must address opposing needs in spousal support disputes, a former spouse petitions to terminate alimony, claiming that the recipient has moved in with a new partner. The recipient argues that they still need support. Under which legal doctrine is alimony most likely to be terminated? A. Cohabitation, if the recipient's financial dependency on alimony has changed due to the new living arrangement. B. Automatic termination upon remarriage of the recipient. C. Termination only if the paying spouse proves the recipient has hidden financial assets. D. Alimony must continue unless the original divorce decree sets specific end date. Answer A. Cohabitation, if the recipient's financial dependency on alimony has changed due to the new living arrangement. Explanation. Most spousal support agreements include termination clauses if the recipient cohabitates with new partner in financially supportive relationship. Courts consider the degree of financial interdependence between the recipient and the new partner, shared living expenses, and whether the new partner provides economic benefits, whether cohabitation resembles marital relationship. Why the other answers are incorrect. B. Incorrect. Remarriage automatically terminates alimony, but cohabitation requires court review based on financial dependency. C. Incorrect. Hidden assets may affect property division, but cohabitation rules apply to alimony termination. D. Incorrect. Courts can modify or terminate alimony based on changed circumstances, even if the divorced did not specify an end date. Question 28. As part of a broader effort to ensure continuity in financial obligations following a divorce, a spouse who agreed to pay alimony for 10 years petitions the court to terminate payments after 5 years, citing early retirement. The recipient opposes the petition, arguing that they still rely on the support. Under which of the following conditions is the court most likely to grant the request to terminate alimony? A. The paying spouse voluntarily retired early and now has reduced income. B. The original divorce decree stated that alimony is modifiable based on substantial financial changes. C. The recipient spouse has not yet remarried and continues to need support. D. Alimony obligations cannot be changed once established in the divorce decree. Answer B. The original divorce decree stated that alimony is modifiable based on substantial financial changes. Explanation. Most courts allow modification or termination of alimony if there is a significant and involuntary change in the paying spouse's financial circumstances. However, voluntary decisions, such as early retirement, are not always sufficient grounds for termination unless the original divorce decree specifies modifiability based on financial changes. The retirement is reasonable and in line with standard retirement age. The recipient has become financially independent or no longer requires support. Why the other answers are incorrect. A. Incorrect. Voluntary early retirement does not automatically justify alimony termination unless it was anticipated in the divorce agreement. C. Incorrect. Continued financial need alone is not enough. The courts can whether modification is justified based on both parties' circumstances. D. Incorrect. Many alimony agreements are modifiable based on substantial changes in income, unless explicitly designated as non-modifiable. Question 29. Within the scope of protecting a child's best interest while enforcing parental obligations, a father who has been paying child support discovers that he is not the biological parent of the child after several years. He petitions the court to terminate child support obligations. Which of the following factors is most likely to determine whether the court grants his request? A. Whether the father voluntarily signed the birth certificate and acknowledged paternity. B. Whether the mother misrepresented the biological paternity at the time of birth. C. Whether the child still has financial needs that require continued support. D. Whether the child has been legally adopted by another person who can assume financial responsibility. Answer A. Whether the father voluntarily signed the birth certificate and acknowledged paternity. Explanation. Courts prioritize the best interests of the child and generally do not allow retroactive cancellation of child support obligations. The key determining factor is legal paternity, which is often established when a person voluntarily signs the birth certificate or an acknowledgement of paternity. The father has acted as a parental figure and support. A child for years, the statute of limitations to challenge paternity has expired. Why the other answers are incorrect. B. Incorrect. Fraud or misrepresentation may be a factor, but courts often prioritize the child's financial security over proven deception. C. Incorrect. A child's continued financial need is important but does not determine paternity obligations. Legal acknowledgement does. D. Incorrect. Child support is only terminated if another legal parent, such as an adoptive parent, assumes responsibility. Question 30. In addressing concerns about fairness in asset division within divorce settlements, a husband claims that his wife is hiding marital assets in offshore accounts before finalizing their divorce. The court orders full financial disclosure, but the wife insists that certain accounts are separate property. What legal remedy is most likely to apply if the court finds evidence of asset concealment? A. The court may award a larger share of the remaining marital assets to the husband as compensation. B. The court can only divide disclosed marital assets and cannot penalize the wife for hidden funds. C. The wife retains her separate accounts unless the husband can prove he contributed money to them. D. The court will require the wife to return all separate property to the marital estate for division. Answer A. The court may award a larger share of the remaining marital assets to the husband as compensation. Explanation. Courts take concealment of marital assets seriously and may impose penalties including granting the other spouse a greater share of disclosed marital property, holding the spouse in contempt of court for failing to disclose assets, ordering reimbursement or redistribution of hidden assets if later discovered. Why the other answers are incorrect. B. Incorrect. Courts can penalize dishonest spouses and are not limited to only disclosed assets. C. Incorrect. Even if an account is separate, failure to disclose assets can lead to sanctions. D. Incorrect. Courts do not automatically reclassify separate property unless fraud is proven, but they may adjust the division of property.